All right. Ms. Holmes. Brittany. Mr. Lewis, are you ready on Wesley Deaver, 3 cases? Okay. Oh, yeah, sure, I'll hold it.
And it's the same one, Ellis Thomas. He's gonna be a plea this morning.
Okay, I'll hold that for a plea. Thank you. Mr. Parker, are you ready on Hunter? Is it Aquin? Aquin.
Yes, Your Honor.
Cause number 23 DCCR 0209 on Hunter Aquin.
I'm signing that.
Okay. Mr. Nichols, you ready on? Mr. Aquin? I'm sorry, Mr. Coleman. Good morning. Good morning, sir. You Hunter Aquin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
So, Your Honor.
Mr. Quinn, you're charged with the first-degree felony offense of aggravated robbery from April 13th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Coyne's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time, find you guilty of the first-degree felony offense of aggravated robbery. Sentence you in accordance with your agreement to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon. I'm handing you the trial court certification that shows this was an agreement, and so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk to your attorney. All right, good luck to you, sir. You can go back with the bailiff. And then Leon Cawley, Mr. Parker. Clause number 23 DCCR 0060. Is there a rejection on this one?
This is the one. Oh, I verified. Oh, it's in my file. I can show it.
I'm telling you, I understand.
Okay.
I hear that.
Good morning. Are you Leon Cawley? Speak up, please.
Yes, ma'am.
And Mr. Colley, you're charged in cause number 23 DCCR 0060 with the first degree felony offense of injury to a child, elderly, or disabled individual from December 14th of 2022. The indictment alleges that you were previously convicted of aggravated assault with a deadly weapon, a second degree felony, December 17th of 2018. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be enhanced with a minimum 15 years in prison up to 99 years or life. Do you understand? And I have before me a plea bargain rejection that has your signature on it with Mr. Parker's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in the institutional division of the Texas Department of Corrections. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. And so, Mr. Colley, Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and we can appoint another attorney to get today who could begin preparation a little quicker for trial. Is that okay with you? Okay, it's up to you either way, but you're good with that? You can? Would you like to?
Yes.
All right, so Mr. Parker will remain on your case and he will begin preparation for trial and we'll get it put on the trial docket. Thank you, sir. You can go back with the bailiff. Then Mr. Parker on Tamilian Fisher, cause number 38399.
Good morning. This case, but I am sorry for that.
Okay. Good morning. Are you Tamilian Fisher?
Yes, ma'am.
And will your client waive the formal reading of the motion?
Will, Your Honor.
Mr. Fisher, in cause number 38399, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 18th of 2022 for the offense of theft. And that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the new offense of aggravated flight from an officer August 5th of 2022 in Calcasieu Parish, Louisiana. And is that true or not true?
Yes, ma'am.
Is it true or not true?
True.
Count 2 alleges that you committed the offense of hit and run driving on August 5th, 2022 in Calcasieu Parish, Louisiana. Is that true or not true?
That's true.
Count 3 alleges that you committed the offense of illegal possession of stolen things August 5th of 2022. Is that true or not true?
That's true.
Judge, if it's okay with the court, I think that would be sufficient.
What is the result of those cases over there?
They all got dropped. Only thing I pled out to was the aggravated flight.
Okay, and what was your punishment for that?
They gave me 4 years probation.
Okay. So the state's going to abandon 4 through 10.
Yes, Your Honor.
Sir, did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Well, the ones that I've read out to you that you said were true, did anybody force you to plead true to those?
No.
And did you plead true because you actually did what they're saying you did to violate your probation?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these documents on the computer, did you go over them with Mr. Parker?
Yes, ma'am.
And do you understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? So you can't change your mind. Do you understand?
Yes, ma'am. Can I say something?
Yes,
I've been in jail a whole year.
right.
And I know I talked to you last time. The time I have been down, like me being in jail in Louisiana, really taught me a lot. This is my first time really just sitting in jail. You know, all the other times I was winding out. and I ain't really just seen what jail felt like.
So, I mean, the agreement that you've made is for a 1-year term in the state jail prison, and you would receive credit for any of the time that you've been in jail. Are you saying that because you don't want me to do this agreement, or you just want me to know that?
I would just let you know, but if
Do you-
I have been in jail a year already,
Uh-huh. You'll get credit for any time that you've been in jail on this case. So that's from your original arrest, and then that's on the MTRP arrest, as long as we had a hold on you, and you were in jail on this. Do you understand?
I've explained that to him. I think he probably has enough time for the time he's set in Louisiana to finalize his case.
Okay. I don't know how much time you have, but by law, you'll get that credit. Okay.
no.
So do you want me to follow this agreement?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Fisher is not competent? All right, Mr. Fisher, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft. Sentence you in accordance with your agreement to a term of 12 months or 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you a trial court certification that shows this was an agreement and I followed it. And so you have given up your right to appeal. So you can't appeal what I just did. And I've handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written document I provided you to see what devices qualify as a firearm.
Yes, ma'am.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. Right? Good luck to you, sir. You can go back with the bailiff. Mr. Parker, Arthur Gray, cause number 23 DCCR 0323.
I need to be educated.
Oh, wow.
Morning.
Good morning. Are you Arthur Gray?
Yes, ma'am.
And Mr. Gray, in clause number 23 DCCR 0323, you're charged with the state jail felony offense of theft of property with 2 or more previous convictions. That's from November 25th of 2022. The indictment alleges you were previously convicted of theft March 6th of 2022 in 2 cases, September 16th of, 2002, September 16th of 2002, September 25th, 2002 in 2 cases,
That's all the same case.
March 31st of 2005, March 30th of 2012, October 30th of 2014, January 16th of 2016, and April 1st of 2019. So would any of those enhance? Right, up to a second degree.
These are
Okay.
two second degrees, what I understand.
I wasn't sure if it's a theft, if they can enhance it above a state jail. I thought it had to be another felony to enhance it above a state jail.
If I believe, so my understanding is that if all of those are thefts because they're theft with prior convictions, then I think Mr. Parker's correct. If there were any thefts that were in and of themselves state jail felonies, then that could enhance.
No, I think how we got there was we were getting, the theft was enhanced because of prior thefts. And then that got us to the state jail. And he has at least 1 third-degree felony from 2016 that happens to be a theft, but it's that third-degree felony. And he also has a 2009 robbery conviction out of the state of Oregon, which those 2 felonies, by my estimation, gets us to the second degree.
Okay,
Those aren't alleged in the indictment. I'm just with the court aware of that.
Okay.
I've given them notice. I filed a notice of enhancement.
okay. So what that means, and it looks like there is one from 2016 that's listed? Is the Orange County case the third degree felony, or is it a different one?
That's the same.
It's not this, excuse me. Yeah, speak.
Well, let me just,
It's their burden.
so here's the thing. If you have, in fact, a third degree felony offense for theft that you were convicted of, and you have a robbery offense that you were convicted of in any state, then those two prior felonies, because they're not state jail felonies, because they're not thefts with prior theft convictions, they're different than that. Those two would enhance this to a second degree felony. Do you understand?
I understand.
Okay, and so if you go to trial and if you're found guilty, and if those two prior cases are true, then the range of punishment would be that of a second degree, which is between 2 years and up to 20 years. Do you understand?
I understand.
And it looks like the state has made an offer, if you wanted to enter a plea of guilty, for an 18-year term in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And even though those aren't in the indictment itself, as long as the state gives notice to your defense attorney of those, they can be used to enhance. I want to make sure you understand that as well.
Yes, ma'am.
Okay, so do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, then we'll get that done. And so, Mr. Gray, Mr. Parker's been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I could release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
That's fine. Yes, ma'am.
So, Mr. Parker, you're released. Mr. Gray, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, thank you.
Thank you, Judge.
Thanks. Mr. Parker, on Daryl Wayne Johnson, cause numbers 28822 and 28824.
Sorry, what's your name?
Daryl Johnson. So, Mr. Nichols, Mr. Parker sent a memo or letter asking that I set bonds because they're deferred. Are you prepared to visit about that today?
We can, Judge.
Okay. All right, so are you Daryl Johnson? And what is the announcement first, Mr.
Your Honor,
Parker?
I've reviewed this at length with him. I believe he has understanding of what his options are. He's requested that, being that he's on deferred, that he wants a bond. He wants to be able to bond out and hire his own attorney. That's where we are right now. I've given him the offer that was given to me, and
So, Mr. Johnson, couple things. First, let's go over what the allegations are. You are on probation in each of your cases for aggravated robbery, and you're on a 10-year deferred probation, right?
Yes, ma'am.
And the allegations, and they haven't been proven, but when I'm looking at the administrative hearing and at your file, this is the third motion to revoke your probation that you've had filed against you. Is that correct?
Yes, ma'am.
Okay, and so you've been continued twice, you've been sent to ISF, and now it looks like the allegations are that you had failed to report since December of 2021. You tested positive for marijuana. You haven't enrolled in your GED program. You haven't successfully completed the moral recognition therapy. You're way behind in your fees. Failed to obtain and maintain employment, provide verification of that, with just kind of excuses after excuses. And so at this point, because you're on a deferred probation, you are entitled to a bond legally. So I'm going to set your bond at $150,000 in each of your cases. right? If you make that bond, there are several conditions that you will have to follow. One is you will have to wear a GPS monitoring device, remain in Jefferson County, Texas, and you will have to wear a drug patch. Do you understand? Now, with regard to the allegations and the motion itself, we just need to go through, you have a couple of options on that. You can accept an agreement that the district attorney has offered you, or we'll go through the motions. You can enter pleas of true or not true. Tell me if the allegations against you are true or not true. And then we'll reset your case for a sentencing hearing. And there can be witnesses brought or just information brought to me. And then the sentence will just be up to me anywhere in the range of punishment. Do you understand?
I have a question.
Okay,
My question, for my,
pull it down for me a second.
this is my first time getting a bond, and when I first was incarcerated, my bond was, it was.
I'm not talking about your bond again. Your bond is set at what your bond is set at based on the allegations and the fact that this is your third motion to revoke your probation and we haven't seen you since 2021. I've set your bond. So now I need to know what you want to do on these motions.
I want time to try to have some legal representative.
So what I'll do, Mr. Johnson, is reset your case for 30 days. If you get someone hired before that next court date, they can get in touch with Mr. Parker in the court, and then we'll see what we can do from there. If you're unable to hire someone before that next court date, then when we come back, we'll need to do something with your case. We can go forward either with an agreement, or if you don't have an agreement, then I will take pleas on the motion and then we'll get it set for sentencing, okay? All right, you can go back with the bailiff. Mr. Parker, cause number 35802 on Alex Lawrence. One of these, because it's already. Well, it should be. Here it is. I got it. Alex Lawrence.
Alex, Mark. It's Ashley.
And it's telling me I can't get into it. Oh, but it let me anyway. Never mind. Good morning. Are you Alex Lawrence? And will your client waive the formal reading of the motion?
Hey, well, Your Honor.
Mr. Lawrence, in cause number 35802, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation April 19th of 2021 for the offense of robbery, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And it alleges that you violated your probation. Count one alleges that you committed the new offense of evading arrest on May 21st of 2022 in Chambers County, Texas. Is that true or not true?
That's true.
Count two alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
False.
Not
Count.
true or not true?
That's okay.
That's
Okay.
false.
Count three alleges that you failed to remain in Jefferson County, Texas, and you were in Chambers County without permission on May 21st of 2022. And is that true or not true?
You said I was in Chambers County?
Yeah, without permission.
Yes, ma'am, that's true.
Okay. And then count four alleges that you haven't done your community service as required. Is that true or not true? Not true. Count five
He said
alleges,
not true, I think.
that's what I put.
I thought he said.
Count five alleges that you failed to pay your court assessed fees as directed. As of June 21st of 2022, you were $569 behind. True or not true?
You said, how many payments I missed?
Well, it just, I haven't,
$569.
$569 behind
Yes, ma'am.
last June.
I think that was when I was in ISF, and she was trying to get that wave. She said she was gonna get.
Okay, it's the whys of it, we're gonna get to later.
Yes, ma'am.
But you think you were behind at some point?
Yes, ma'am.
Okay, so we'll put true for 5. Did you enter your pleas of true to counts 1, 3, and 5 freely and voluntarily?
Yes, ma'am.
And because those are actually true.
Yes, ma'am.
So I have some documents here on the computer that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
A little bit.
Okay, do you understand them?
A little bit.
What do you not understand?
I don't understand, like, I'm not trying to sign for 8 years.
Well,
Your Honor.
so here's the thing, Mr. Lawrence. when you're on a probation, a couple things, there's kind of two paths that you can take when you have violated your probation, right? One is just to leave your punishment up to me within the whole range of punishment, which in this case is a second-degree felony, which means if you pled true to certain things, or if the state proved those things true, then I could give you 20 years, no questions asked, right? Because you violated your probation. I can give you 2 years up to 20 years. The agreement that you've made is that you have limited me by an agreement with the state to 8 years. I can give you 8 years in prison. I can leave you on probation. I can give you 7, 6, 5, all the way down to 2 years. It'll be up to me. But what Mr. Parker's done is work to at least cap that for you so that you don't have the full range of punishment, right? So if I do this, what'll happen is I'll reset your case so that the probation department can do an updated report. Mr. Parker can get any information he thinks that you want to give me. We come back at a later date for sentencing. You're able to talk to me, tell me what's been going on. The state can talk, Mr. Parker can talk, and then I'll make a decision. And it's somewhere in that range of punishment, but no more than 8. Do you understand? Okay. And is that what you want me to do? State tenders number 1.
No objection.
It's admitted. Any evidence Mr. Lawrence is not competent.
No, Your Honor.
All right, Mr. Lawrence, I'm going to find that you entered your pleas of true to counts 1, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm resetting your case again so we can get that updated report. We'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker. He'll present it to me on your behalf when we come back, and then we'll go from there. All right? You can go back with the bailiff. Yes, ma'am. Huh? Okay. Cause number 23 DCCR 0174 on Christopher Montalvo. Mr. Parker. I just hate it when you do that because it just makes me so large. That's my main problem with it. I forgot the other day to say something about these indictments. I'm telling you, I'm having a hard time reading them. I need to, this afternoon, I can maybe talk to them. No, they're terrible. I can't read them because the watermark is so prominent.
It's not a watermark.
It's, yeah. And I had to do an amendment on one and I was had to mark through, and you couldn't even see what I was trying to do because it's too much. The new,
Clerk,
that's y'all.
what's up?
We've talked about,
Sarah?
mhm.
Okay.
There's some reasons behind it, but we've got to figure it out. Sir, are you Christopher Montalvo?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And are we going on count 1 only?
Sure.
Mr. Montalvo, the state selected to proceed on count 1 only in cause number 23 DCCR 0174. You're charged with second-degree felony offense of robbery from February 20th of 2023. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
I did.
Do you fully understand them?
Yes, ma'am. It's non-aggravated, right?
Correct. And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am. I understand.
And do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number
No
1.
objection.
It's admitted. Any evidence Mr. Montalvo is not competent?
No, Your
Just
Honor.
wait. Mr. Montalvo, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the second-degree felony offense of robbery. sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. Thank you. Clause number 23 DCCR 0283 on Dwayne Watson. Parker.
Very much welcome.
Good morning. Are you Dwayne Watson?
Yes, ma'am.
And will Mr. Watson waive the formal reading of the indictment?
You will, Your Honor.
And are we going on count one only?
Yes.
Mr. Watson, in cause number 23 DCCR 0283, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of unlawful possession of a firearm by felon from January 3rd of 2023. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And my understanding of your agreement is that you would receive a 10-year term in prison, but that would be probated. You'd be placed on probation for 10 years. There would be a $500 fine and all of the regular conditions that go along with probation. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Watson is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Mr. Smith, what is the state's position with regard to bond based on the nature of the plea agreement? Looks like the two priors in the indictment are very old, but is there anything else? Any reason?
I'm checking the judge.
Is there still a hold out of, let's see, do you have a case pending in Harris County, a possession of a controlled substance?
No, ma'am. I already said that.
You did?
Yeah, I don't have no cases. pending.
Okay.
Last felony I see is in the 90s.
I'm sorry.
So the last felony I see was in the 90s.
So based on the nature of your plea agreement, what I'm going to do, Mr. Watson, is reduce your bond to $1,000. All right. So there's a couple of things that are very important about that if you can make that bond. The first thing is, if you make that bond, the first thing you do is go to the probation department so they can do that pre-sentence report. If you don't do that, then when you come back, you run the risk of me not accepting the plea agreement. Things could be much worse.
Yes, ma'am.
Also, if you make that bond and you are arrested for anything before sentencing, then you run the risk of me not accepting the plea agreement, things being much worse. Do you understand? All right, we'll see you back at sentencing. Thank you. Numbers 29922 and 23 DCCR 0550 on Sandra Angel. Mr. Rojas.
The last name is Warren. MTRC.
Oh, it is Sandra Warren on the MTRP.
Mary's name is
Ma'am?
Angel.
I see that. Is there paperwork just on one though?
No,
We should have two. We should have two.
Oh, it's because of the other name. Gotcha. Good morning. Are you Sandra Michelle Warren and also known as Sandra Michelle Angel?
Yes, ma'am. Good morning.
And Mr. Rojas, will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Miss, which one do you prefer to go by?
Sandra Warren, ma'am.
Warren. So Miss Warren, in cause number 23 DCCR 0550, you're charged with the state jail felony offense of possession of a controlled substance from October 30th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am, I am.
And because you actually did what they charged you with?
Yes, ma'am, I did.
In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am, I did.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I have to ask everyone. State tenders number 1 in that case.
Objection.
It's admitted. Any evidence that Ms. Angel is not competent,
No,
or
Your
Ms. Warren. All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with that agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Anna, that one doesn't have your signature on the page. And then in cause number 29922, I have a motion to revoke your unadjudicated probation. Shows you were placed on probation January 28th of 2019 for aggravated assault. That was a 4-year deferred probation that's been extended 3 years. Is that correct?
Yes, ma'am, I have.
It alleges that you violated your probation in count 1 by committing the new offense of possession of a controlled substance from October 30th of 2022, the one that we just went over. And is that true or not true?
That's true.
You
Count
can
2,
abandon count 2. It's the same thing. I believe, Judge.
all right. Count 3 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
That's true.
Count 4 alleges that you failed to pay your court-assessed fees as directed. As of November 14th, 2022, you were $5,330 behind. True or not true?
That's true.
And then count 5 alleges that you failed to adhere to the rules and guidelines of the zero tolerance supervision as directed. Is that true or not true? Did you enter your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
I also have here on the computer some documents in this case that have your signature on them that the state's marked as exhibit number 1. Did you also go over those with Mr. Rojas?
Yes, ma'am, I did.
And do you fully understand those as well?
Yes, ma'am, I did.
State tenders number 1,
No objection.
it's admitted. Ms. Warren, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of the offense of aggravated assault. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Will be an affirmative finding of a deadly weapon in that case, and these cases will run concurrently, which means together at the same time. I'm handing you the trial court certification in each of your cases that shows these were agreements that I followed, and so you have waived any right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Rojas. Good luck to you, ma'am.
Thank you, ma'am.
Yes, sir. Yes, ma'am. Is Janice Delafosse here? Come up, Ms. Delafosse. What's the add-on? It's 40918. So, Ms. Delafosse, you're on bond, and a condition of that bond was for you to have a drug patch. And we have been having all kinds of trouble with you and your drug patches. And so what I'm going to do this morning is have you drug tested, and then we're going to go from there. Have a seat in the jury box. Cause numbers 34630, 37138, and 23 DCCR 0707 on Wesley Deaver. Morning, Mr. Lewis. Thank you. All right, are you Wesley Deaver?
Yes, ma'am.
And so Mr. Deaver was previously here, entered some pleas of true in motions to revoke community supervision. We got an updated report done, and then there's a new offense. It looks like there's an agreement on. Is that correct?
That's correct.
My question on the other two, were those agreed to, or were those caps?
So initially, one of them was assigned to me and I made a cap offer. And then the other one was going to run concurrent with it, but that was a straight time offer. So it's agreed, one is a cap, one's not. I don't really have a preference on how the court addresses it.
Okay, so the injury to a child, cause number 34630 was a cap of 5 years.
Right.
But there's an actual agreement for 21 months
on the state jail.
on the state jail. And
And those-
37138, and the agreement on the new case, it looks like is for 9 months to run concurrently with whatever I do. Gotcha. Okay. Okay, so let's go through the new case first, and then we'll talk about sentencing. And will he waive the formal reading of the indictment? Did I already say that?
He does.
Okay, Mr. Deaver, in cause number 23 DCCR 0707, you're charged with unauthorized use of a motor vehicle. It's a state jail felony from March 14th of 2023. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you actually did what they charged you with?
Yes, Your Honor.
And I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1,
No good.
it's admitted. Any evidence that Mr. Deaver is not competent?
No.
All right, sir, in cause number 23 DCCR 0707, I'm going to find that you entered the plea of guilty freely and voluntarily. find that you're mentally competent, you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time, find you guilty of unauthorized use of a vehicle, sentence you in accordance with that agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, Your Honor.
See. Did I print it? Okay, just make- all right, now, has everyone had an opportunity? I've received in the other two cases an updated pre-sentence report. Has everyone received and had an opportunity to review that report?
Had you.
Yes, sir.
And is there any reason not to go forward with those because of the new plea or anything like that?
No.
And it was our intention that they all run. concurrent.
With that, correct. Okay. So, Mr. Lewis, you may proceed then.
Well, Judge, of course, at the time we did the plea, we didn't know about the new case coming in, but as soon as it was indicted, Mr. Deaver did accept full responsibility for his actions. He understands, he has not done his best of what he could do on probation. I have had a chance to speak with his family who now at this point really able to step up as a support system for him. We understand that the cap is at 5. We are asking if possible to pull the city 3 on that one to run with the other 2 cases. My understanding is that there is some employment opportunities that will be available to him once he's able to get back to his family. He was a stepfather that I met with that he was actually here in court last time, but couldn't be here today. But they're saying they're definitely willing to help him, stay on the right track. I think a lot of it was some of the people he was involved with, for friends he had, cut out that group and be more, of course, with his family, people that had his businesses apart. So that's what we're asking for.
All right. Thank you, Mr. Lewis. Ms. Lesniak.
I'm asking for 5, just because the underlying facts of the original offense were pretty egregious. And it doesn't look like Mr. Deaver has really availed himself of any of the opportunities that probation had to offer regarding that. So due to that, we're asking.
Give me just a second. All right. Anything else?
No.
All right, so the original agreement in that injury to a child was a 10-year term in prison, which is what you could get for violating. Mr. Lewis has done a good job limiting your exposure to that 5 years. In cause number 34630, Mr. Deaver, I'm going to find that you entered your pleas of true previously to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment at a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 37138. I'm also going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. And in that case, I'm going to follow the agreement and reassess your punishment at a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I'm handing you in each of your cases trial court certifications that shows these were agreements that I followed, and so you've waived any right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. And I think I probably went over that with you when you initially got put on probation, did I?
Yeah, sure.
So obviously that is important. You need to make sure and read that because of the judgments entered against you. You cannot possess a firearm. Do you understand?
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff. Clause numbers 23 DCCR 0487 and 0488 on Ellis Thomas, or I'm sorry, Patrick Thomas Ellis. Yeah, I see that one. Good morning, sir. Are you Patrick Thomas Ellis?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each
He
case?
does.
Mr. Ellis, in clause number 23, DCCR 0488. Let's see, are we going on count one in each of these cases?
Yes, ma'am.
The state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of possession of a controlled substance, penalty group 1 from September 7th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer, well, in, let me go to the other one. In clause number 23, DCCR 0487, you're also charged with the third-degree felony offense of possession of a controlled substance, penalty group 1 from September 7th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty in that case freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreements. Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Any evidence that Mr. Ellis is not competent?
Yes, ma'am.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of those pleas. In cause number 23 DCCR 0487, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23 DCCR 0488, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of possession of a controlled substance. Sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
The record.
It should be- I'm getting there. These two will run concurrently, which means together at the same time. And I'm going to sign a dismissal in cause number 41042 as part of that plea agreement. I'm handing you the written admonishments regarding, well, 2 things. The trial court certification that shows these were agreements that I followed, so you waived your right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this at this point, but I'm required to read this to you. Because of the judgments entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right. Good luck to you, sir. You can go back with the bailiff. Clause number 23 DCCR 0257 on Jacob Odell. Ms. Holmes. you. Ms. Holmes, good morning. All right, sir, you're Jacob Odell. And will your client waive the formal reading of the indictment? And are we going on count one only?
Yes,
On the state's okay with it.
All right, Mr. Odell, in cause number 23 DCCR 0257, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on a public servant from March 16th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
no objection.
It's admitted. Any evidence that Mr. Odell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a public servant. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived any right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes, right? Good luck to you, sir. You can go back with the bailiff. Ms. Washington, Ms. Holmes.
She did provide me with a list of medications and I'll provide to the court.
Well, and we've been through this before, and I know you're on some medications, Ms. Delafosse, but I want to make sure that the medications you're using obviously are the ones prescribed, and that there's nothing else in your system, which is why I required you to have a drug patch. So why don't you have a drug patch? Why didn't you have one before?
It had, the drug patch had came off.
And why didn't you go the day that it came off back to get one put on instead of waiting for 2 months, which is, I believe, or at least a month and a half or so, if I recall?
Okay, this is what happened. It came off. I didn't have the money because I'm on disability. I didn't have the money to go to get another drug patch. And I flushed all my medications down the toilet. And I
Why?
ended up having a mental breakdown. My doctor ended up making me get back on my medication. And I called Mr. Johnny and I explained to Mr. Johnny the situation and what I had went through. And he explained to me if the event that they do get patches that falls off in the event that if it happens again, he said, call him directly and he will tell them to put a new patch on me.
Have you ever been or gone, Ms. Delafosse? I mean, well, let me ask you this: is any of your doctors for mental health? Like, do you have a psychologist or a psychiatrist?
I had one, I'm in the process of getting another one because I spent time in a mental hospital.
So here's what we're gonna do, all right? Because I've got to make sure that a couple of things. Number one, that you're doing the right thing on bond. I'm going to require as a condition of your bond that you get in contact with Spindletop MHMR and that you follow through with any medication or treatment. And I want to know that you've done that within a week. So you need to call this week
Yes, ma'am.
because you've been a patient there before, right?
Yes, ma'am.
So-
And I've been a patient at Baptist Behavior Center. too.
Okay, so I want you to make sure, Ms. Holmes, if you'll make sure that we're gonna amend the conditions of her bond, that you explain all of that, what that means, that I want some type of confirmation that you have an appointment or have actually gone within a week. I'm not gonna make you come back next week. I'm gonna reset it for 2 weeks. And on a Monday morning in 2 weeks. Are you here in 2 weeks?
Should be.
Mm-mm.
And
Let's check on this.
Miss-
Yes.
Hang on. So, hi,
Hey, mental health officer here.
Oh,
You
good.
need To be at Spindletop tomorrow before 7:45 so that you can go through the intake process. It shouldn't take you a week. Judge, they're backed up for about a month on your doctor's appointment.
okay,
But she will be able to receive her intake with a LBC counselor. and
Okay.
they'll give her the doctor's.
thank you for being here, good. Okay, so Ms. Della Fosse, before you leave today, I want you to visit with the person who's here. She is a mental health officer that's here to help. She's gonna make sure you know where to go, what time you need to be there. Get that done, get that information to Ms. Holmes, and I won't necessarily I'll just do a normal reset, which is about 30 days. Here's the thing, if you don't go, when that lady tells you to go,
Yeah, she said for me to be there for 7:45 in the morning.
so if
I'm
you,
gonna be there.
okay, if you're not there, then there's gonna be a warrant for your arrest and you're gonna end up in jail because we're not gonna keep doing all of this, okay? So it's very important that you follow all of those rules
Yes.
and then stay in touch with Ms. Holmes so she can get that information to me that I know you've done it.
Yes,
okay.
ma'am.
Don't leave without talking to her.
I will.
Okay, you're free to go.
Thank you.
Yes, ma'am.
Oh, I have one question.
What's that?
Do I give Ms. Holmes all my medical records that you requested for me to get?
I'm okay right now with where we are. If she needs anything for your case, you can get that to her, get copies of it. I don't need anything for the file at this point. Okay?
Okay.
Thank you for bringing them though. Clause number 38675 on Cadero Matthews. Mr. Rojas.
Okay.
Good morning. Are you Cadero Matthews? And will your client waive the formal reading of the motion?
Here we are.
Mr. Matthews, in clause number 38675, I have a motion to revoke your community supervision. Shows that you were placed on probation November 14th of 2022 for the offense of unlawful possession of a firearm by a felon. That was a 5-year sentence in prison, and then you were placed on probation for 5 years, right?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of promotion of prostitution March 23rd of 2023 in Mobile County, Alabama. And is that true or not true?
Yes, ma'am. It's true.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that.
Yes, ma'am.
Is that true?
True.
Count 3 alleges that you failed to remain in Jefferson County as you were supposed to because you were in Mobile County, Alabama without permission.
True.
And then finally, count 4 alleges that you failed to provide verification of performing community services required. All right. Did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily? And because they're all actually true. I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you understand them? And you understand if I follow this agreement, a couple things. Number 1, if I follow this agreement, you're very lucky today. Number 2, if I follow this agreement, then you cannot appeal or change your mind. You understand? Looks like you've come up with an agreement with the district attorney's office that I would continue you on probation and order a 90-day jail term as a sanction. Is that your understanding? Tell me what's going on with these other cases.
30 days in jail to a misdemeanor, based on some, just kind of Alabama, the court record, we have probation obtained from Alabama.
Okay. And are you in agreement with this for him? All right. So Mr. Matthew, state tenders number 1.
No objection.
It's admitted any evidence Mr. Matthews is not competent.
No, Your Honor.
All right, Mr. Matthews, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to follow the agreement that you've made, give you this opportunity. It's very important that you understand the opportunity that you're being given. You have criminal history. If you violate this probation again, I can probably assure you that you will not come in and get this type of deal again. I'm going to order that you serve 90 days in the Jefferson County Jail as a sanction. Is the agreement for him to get? That's
I think he has about 2 months in, Your Honor.
so you'll get credit since you've been in custody on this motion to revoke, not the case from the original, just since you've been in on the motion to revoke. So whatever you have on that, that will apply. If you don't have the full 90 days, then you'll have some to do left. Do you understand? All right, I'm handing you the trial court certification, shows this was an agreement that I followed, so you've waived any right to appeal. As soon as you're released from custody, make sure you get in touch with probation, do everything you're supposed to so that you're not back in here again. All right, thank you.
Thank you, Your Honor.
Ms. Perazzo, cause number 23 DCCR 0324 on Florencio Gillen.
Good morning, Your Honor.
Good morning.
Mr.
Hold on a second. We gotta get him out here.
Okay. Interpreter. And I have an interpreter.
Okay, you can bring him up.
Okay. Do you want to just stand here? in the front?
Just right there is fine. Ma'am, would you state your name for the record, please?
Maria again.
And just for future purposes, I think what we'll need to do is have not a family member. If you need an interpreter from this point forward, just let the clerk know. We'll have someone here. And so, Ms. Guillen, raise your right hand, please. Do you swear or affirm that you will accurately and truthfully translate from English to Spanish and Spanish to English to help you God? Thank you. So it looks like we're here on an announcement. There was a motion to reduce bond filed. Why does it say it's not set for a hearing?
It's not set for a bond hearing. That was just all this. I'm sorry, that was.
We can take it up here.
Okay.
That was for me to tell me I didn't set it for a bond.
Oh, it
Set
was,
for an announcement.
okay. It shows it was filed on the 7th
I know, but I didn't,
because that was
I
a
was on vacation.
Yeah,
and I
gotcha.
saw it yesterday.
perfect, understand. But you're ready to proceed?
Yes, sir.
So Mr. Guillen's charged with the first-degree felony offense of murder from February 27th of 2023. Ms. Carrazzo, you may go forward, I guess, on that motion.
Yes, Your Honor.
Yeah, go ahead. You can, go ahead, tell him. Okay,
Okay, so Your Honor, we are requesting that Mr. Guillen's bond be reduced from $1 million to $100,000. It's my understanding that Mr. Guillen doesn't have any substantial, if any, criminal history, that he doesn't pose a flight risk, and And he has ties to the community. He was residing in Jefferson County at the time of this alleged offense. And he was gainfully employed at the time as well. And he has family members and friends and coworkers that reside in this area. In other words, he has substantial ties to the community.
Right.
And there is no reason for him to not miss any further court dates. And
What about, I need some information with regard to his ability to pay.
Your Honor, he could have the ability to pay if the bond or satisfy a bond in the amount of $100,000 if the court so inclined to reduce that, or to reduce the $1 million to $100,000.
Mr. Nichols?
Your Honor, I'm going to tender the court without marking states exhibits 1 and 2. And I'm sorry, Your Honor, these are crime scene photos. And given the nature of this offense, this is a machete attack against a coworker. I don't feel safe at night with this man being out.
Your Honor, I have seen the photos. We are actually in the process of reviewing all of the discovery at the moment. I would also need some additional time to finish reviewing all of the discovery. Of course, we haven't filed anything yet, but if we do decide to proceed to trial, we will be filing a motion of our intent to offer the self-defense or the affirmative defense of self-defense in this case, Your Honor. Without going into, I'm not going to go into any of the arguments as to why we would do that, but it's our position that he doesn't pose a risk. He was merely protecting himself.
So my position at this point would be, before I would consider reducing the bond, I would ask the state to probably present at least the detective with a little more information on the case. The probable cause doesn't say much about, if anything, what they found or kind of what happened. I will admit states 1 and 2 for purposes of this hearing. I'll reset the hearing. I'm going to hold making an judgment on that or reducing it at this point. And if you can see, maybe either next week or the week after, get someone here that can give just a little more information. Obviously, it's not going to be a trial on the facts of the case, but I am part of the code says that I can take into consideration the nature of the offense as well as all of the other factors. And so I want to have a little more information about that.
Certainly.
Yes, ma'am.
And then we'll just reset. What I'll do now is reset it, a normal reset. Actually, what do you think?
I don't see any reason we couldn't do it next week, Your Honor.
It's a lot next week, I think.
Then there's a reason we could not do it next week. I just don't know. I don't know our status on our docket next week. Is Monday and Wednesday both?
Well, we would want to do it on it'll be a Tuesday.
Tuesday,
So let's go ahead and because it's a motion for bond, we'll set it next week on Tuesday. If you have an issue with getting anybody here, let us know. We can bump that back a week, and then I'll give you time after that for preparation.
Thank you, Your
Okay,
Honor.
thank you. Do you get these, or do these go with me because they're just in a bond hearing? I can't remember. I'm not sure either.
You don't wanna look too hard.
No, don't. You really don't.
Sorry, that's what I'm talking about. Sorry.
Little more heads up on that would have been appreciated. Not sure if I've ever seen anything like that before. Mr. Samuel?
Yes, Your Honor.
On Christopher Collins, cause numbers 41324 and 23 DCCR 0118.
Yes, Your Honor.
Good morning. How are you today?
It's a great day. I woke up again.
There you go.
Um,
Good morning, sir. You're Christopher Collins. And Mr. Collins is charged with murder and also driving while intoxicated, third or more. Mr. Samuel, what's the
Yes.
announcement?
Your Honor, we're requesting, this is my first sitting on this. I visited with the prosecutor. We have a possible resolution by way of a lesser included.
Okay,
He needs some time and we
Sure.
should be able to get,
and you're on both of the cases, correct? Mr. Smith was Bruce Smith, it looks like, and then you got on, or is that?
I was appointed. Yes, ma'am.
Okay, gotcha.
Judge, I'd like to contact the family and just let them know where we're headed.
Sure. Just a normal reset?
Just normal.
Okay, I'll just do a normal reset. If something happens and you guys want to bump it up, if there's an agreement, we can always do that and get them over here and get that taken care of before that court date.
That is what you wanted to do. Is that correct? We're resetting, we're visiting about resolving it. He's making the contacts that I told you.
Yes, sir. Oh, yes.
All right, so I'm going to just do a normal reset at about 30 days to give them some more time. I'm sure Mr. Samuel will be out there to visit with you about what he's found out, what the offer is. And if you want to accept that, we can take care of it when you come back. If you don't, then we can get your cases set for trial.
Yes, ma'am.
All right, thank you.
Thank you.
Thank you, Mr. Samuel.
Thank you, Your Honor.
Mr. Vasquez, on Paul Westbrook's cause numbers 23 DCCR 0328 and 0329.
Good morning.
Good morning, how are you?
Good. Thank you for waiting. Thank you, Kelly. Thank you, Kelly.
Oh, I didn't even know I was waiting.
Oh, never mind now. Save my excuses for another time. Good morning.
Good morning, you're Paul Westbrooks.
Yes, ma'am.
And Mr. Westbrooks is charged in 0328 with capital murder by terroristic threat or other felony from April 10th of 2023, and in 0329 charged with first degree felony offense of murder from April 10th of 2023. And Mr. Vasquez, what is the announcement?
Judge, we're asking for another announcement. I've seen everything that's been submitted to the discovery page so far, but I have not shared it all with Mr. Westbrook yet.
All right, so I am going to take judicial notice of the court's file. The state has filed in cause number 23 DCCR 0328 states notice not to seek the death penalty. And so obviously we're going forward in that manner. Mr. Westbrook, I'm going to reset your case for about 30 days. Mr. Vasquez, if you'll just make sure and get out there, visit with him about everything you have, we'll see where we get at that next court date.
Thank you.
Thank you.
Thank you.
Thank you, Phil.
Mr. Parker, on Patience Morgan, 3 cases, 38153, 38154, and 40698.
Your Honor, when I went out to visit her, she informed me that she had hired Rife.
Okay,
And so I haven't discussed the plea offer with her because I didn't want to talk to her. She had a lawyer.
okay. We haven't received anything yet from Mr. Kimler, and so the only thing I can do at this point, I'm going to reset your case. Mr. Parker, if you'll get in touch with him, and if y'all will get. Yeah, make sure he sends, if we can get
I'll
in touch
call
with him to get a letter sent, notice of representation, then we'll get it set when he is back from his vacation.
I'll call Rife.
All right, you can go back with the bailiff. Thank you. You are the docket.
14 cases.
Let's see, cause numbers 23 DCC R 0084 and 0085 on Brandy Nemeth. Good morning. Are you Brandy Nemeth?
Yes, ma'am.
And Ms. Nemeth was previously in court and entered a plea of guilty in cause number 23 DCCR 0084, which was assault on a peace officer. I've received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Any additions or corrections?
No, no, we're okay.
Not from this day.
And the agreement is to dismiss
Correct.
0085, correct?
Yes, sir.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a peace officer. I'm going to sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but suspend that and place you on probation for 10 years. You're ordered to pay a $500 fine and follow all of the rules and conditions of probation. It's important. Obviously, you've been on probation before and you weren't successful. So this is a great opportunity for you to get probation again. So I want to make sure you understand from the beginning that you need to follow all of the rules and recommendations. That includes anything with regard to drug use and drug treatment. If they feel like that's necessary, then you're ordered to participate in that. You're going to have a referral for a mental health assessment. If there's any issues that you need help with, then that's what they're there for. You have to follow any of those recommendations. If you do all of that and complete this probation successfully, then for all practical purposes, your case here in court is over and you'll be able to serve that 10-year sentence out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
And I will sign a dismissal as soon as it comes through in 0085. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. You're also being handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Parker. Good luck to you, ma'am.
Thanks.
All right, cause number 40419 on Joshua Perry. They can come in. We're close to being done, so I'll be able to visit with them maybe. It's only 10:30.
I didn't realize I was the only one. You know what I mean.
We're doing good. All right, good morning. Are you Joshua Perry?
Yes.
And what is the announcement?
Judge, we had an agreement, but he informed me this morning that he did not want the agreement and he wanted to talk to the court. It's a state jail felony. So I don't know if we just need to go through the motion
Yeah,
or
so
what.
here's the options, Mr. Perry. You have two things. First of all, what we have to do is go through the motion itself, and I have to know, you'll enter pleas of true, whether or not the allegations that you violated are true or not true. If you have an agreement for your punishment and I like that agreement, then I'll go along with it. If not, then, oh, they're little ones. If not, then we'll go through the agreement, and then your punishment is just up to me. And what'll happen is I would reset your case because I'll need the probation department do an updated report. And then if there's any information that you want to give Mr. Parker, he'll present it to me. We'll have a hearing. You'll be able to explain or talk, and then I'll decide what to do at that point. Do you understand? So do you want to accept that agreement, or do you just want to go through it and leave it up to me, and we'll do that the other way with the pre-sentence report and things like that?
You'll be given a chance at that. If you want to do that and talk to the judge, you'll get a chance to talk to her at that time. If you
Right. Today, there's no today, if you were to talk to me and try to explain, it really doesn't matter because I'm not going to make a decision today, and I'll forget what you tell me before we come back. Right. So we'll go through the motion, we'll get the pleas, we'll reset it for sentencing. You'll be able to tell me anything and everything, why you should either be left on probation or get a different sentencing than what they're offering. But then your punishment will just be left up to me on that day. Is that what you want to do? Okay, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
You will, Your Honor.
And I want to make sure, no recording while we're in court. No, okay, we're gonna be done in just a minute. We'll be able to visit and all that. All right, thank you.
Judge, I need to make it perfectly clear on the record, his probation actually expired in April of 22. So the ability for him to remain on probation, I believe, is over. We can't do that because it's
That's
been more than a
correct.
year.
Well, the motion was filed. Is it from when the motion was filed, though?
It's a year from when the probation ended,
Okay, when did the probation end?
April of 22.
The motion was filed June of 23. Was he ever extended? Because if not, then were you extended? I don't know. I mean, probation didn't send this over until May. I mean, it got taken care of within a week, but oh, that's a first amended. Hold on. The original motion to revoke was filed May 4th of 2021. And so what that means is because that amount of time has passed since the end of the probation, that year, it goes 1 year, that I don't have the opportunity to extend or continue you on probation. The only thing I can do is revoke you. So the only question at that point would be, how long would I sentence you, or what would that sentence be? Do you understand? You answer out loud.
yes, ma'am.
Okay, and so knowing that, you still want to go forward, we'll go through the motion and then we'll reset it for sentencing? Or do you want to accept the agreement that's been offered to you? Mr. Berry? I mean, and I don't want to be I'm sure Mr. Parker has gone over all of that with you, so this isn't necessarily new information, but what I can do if you want is reset your case for a couple of weeks for you to think about that and come back and decide then. But with that, it just postpones kind of that process, but whatever, if you would rather do that, then I can. You want me to reset it? All right, we'll reset it 2 weeks. And it looks like, Mr. Parker, you have one more, Londi, huh? Okay, Londi Vic, cause number 23 DCCR 0278. So this is the last case, and then I'll be able to visit with everybody. I know. I know. You think I need to behave? I don't know. Oh. All right, are you Londi Vic? And this is cause number 23 DCCR 0278. I'm going to take judicial notice of the court's file. It includes an evaluation for competency that was prepared by Dr. Capon, dated June 16th of 2023. The finding in this report is that Ms. Vick is currently not competent to stand trial. Is there any other evidence with regard to competency? Then at this time, based on that evidence of the report, I am going to find that Ms. Vick is currently not competent to stand trial. Find that inpatient treatment for competency restoration is required in order that she be sent to the appropriate facility for a period of not to exceed 120 days from the date she arrives at that facility, and then we will wait a report from that facility on competency. You can go back with the bailiff. That's it. Do you have a dismissal for me?